Hi, my name is Robert Chelle with Chelle Law, and I'm an attorney that assists dental associates with employment contract and independent contractor agreement issues. Today I'm going to talk about non-competes for dental associates. So, what goes into a non-compete, and then kind of the red flags, what to avoid before you sign a contract that contains a non-compete. So first, determining the state that you're in is going to be very important for a non-compete. There are very few terms in any dental associate's employment contract or independent contractor agreement that are going to be state specific. Really the only one that matters and varies state to state is the non-compete, or perhaps the non-solicit, kind of any of the restrictive covenants. So you need to identify if non-competes are enforceable in the state or not. There are a handful of states currently that have just outright banned non-competes for healthcare professionals, or in some states just entirely for any profession. More and more states have put restrictions on non-competes. I find specifically for physicians has kind of been each year there's a few more states that add that. In some states, dentists have not been added to the definition of a healthcare provider, and many states have done just physician-specific non-compete changes. I do think over time those definitions will extend to others, veterinarians, dentists, chiropractors, physical therapists, that type of thing. But you may have heard, I heard non-competes have been changed in the state. You need to make certain that if that's the case, that you're in a state where the definition has been extended to dentists and dental associates. So that's the first thing. Next, what goes into a standard non-compete? Well, it really has three components. One, kind of the scope. What can't you do? So you can't work as a general dentist in X, which would be the geographic restriction. So generally, 5, 10, 15 miles from your primary practice location. And then there's temporal restriction, meaning how long does it last? Generally somewhere between 1 to 2 years. So those are the three components that go into a non-compete. Let's break down some of the things you need to be aware of. So first, what you're restricted from doing. If you're in a subspecialty, maybe you do endo, maybe you do orthodontics, you want to make sure that the limitation is just what you're doing for that provider. So in the worst case scenario, maybe you could switch and do general dentistry if you're in a situation where you absolutely cannot move and you must be, within 10 miles of the clinic that you're working for. So you don't want it to say just general dentistry, or you can't practice as a dentist within X amount. So if you're a specialist, limit it to the specialty that you're doing for that employer. All right, next, the temporal restriction, so how long it lasts. Generally, I won't accept a non-compete that lasts more than a year. Most courts will find 1 year is reasonable. Beyond that, it's kind of iffy, but you will see places try to push it to 2 years, but I would fight hard to keep it at 1 year. Below 1 year is not common, so I'd say 1 year is kind of the sweet spot for what would be considered reasonable non-compete time restriction. And then lastly, the geographic restriction, and this one has, a little more nuance to it. It should be your primary practice location, and based upon where you are geographically, it can kind of change what's fair and what's not. If you're in New York City, it could be a few blocks, whereas if you're in a rural environment, 20 miles might be considered reasonable. But what you want to be careful of is, especially with the kind of the proliferation of DSOs, and they have a bunch of different locations in an area, you don't want it to attach to anywhere that you haven't worked. So for instance, it may say, you can't practice within 10 miles of any location of an employer. And not really fair to stop you from working somewhere where you didn't provide care. So you want to limit it to just where you are working, and even better, the primary location where you're working. So maybe you're working at 3 different locations, but you're only doing, maybe you're at 80% of your time at one location and 10% at the others. Well, you want language in the contract that just states, it only attaches to any location where you're, generating maybe 50% or more of your charges, and then that would only be one location, obviously, or 40% of your charges, so that can maybe be 2. But what you don't want is having an employer understand that if they just stick you in one location for one day a year, that the non-compete attaches to that. So you want to be careful of that. I mean, that would be some some shady practices by the employer, but it happens. So be careful that it doesn't say anywhere that you've worked. And then you also want to limit that language as well. So it's anywhere that you've worked, I would say over the last 12 months. Someone can work somewhere for 5 years, and if it says, attaches to anywhere you've worked while working for the employer, you could have worked somewhere 5 years ago, haven't been there, still attaches to that location. So those are the main things you need to be aware of, is limiting the scope, limiting the time, and then limiting the geographic restriction as well. One point about the geographic restriction, it's as the crow flies, meaning it's not a street 5 miles. It is stick a pin and then 5 miles out. That's where it would apply to. So like a 5 mile radius amongst, beyond the clinic location. Sometimes that trips people up. So a lot to think about when a non-compete is analyzed. This can sometimes be the most important thing for somebody. Like for instance, if you are grew up in a location or have kids going to school or have family there, and it's like no matter what, I cannot move from where I am, then making certain that the non-compete is not going to kneecap you for a long period of time is very important. And then last thing, if you're an independent contractor just doing some, fill in some daily rate type work for somebody, a couple times a month, you absolutely should not agree to a non-compete for a position like that. It should really be reserved for full-time positions where you are working, like a standard 4 or 5 day week. Filling in 1 day a month absolutely should not have non-compete concerns attached to it. All right, well, hopefully that was helpful. If you have any questions about your employment or independent contractor agreements, feel free to contact my law firm. Our contact info is listed below in the description, and I appreciate you watching the video. Thanks.